All right. We will open this meeting of the Elections Committee in the Kansas House this February the 17th, 2022. We'll start with the possible approval of the minutes of February the 8th and 10th. If you've received them, if there's a motion to approve, I would receive that. Been moved by Representative Neighbor and Representative Proctor is seconded. The motion for the committee is to approve the minutes of February the 8th and 10th, and it's been moved and seconded. All in favor, say aye. Aye. All opposed? Abstain, and it passes. I have a statement to make. I missed one testimony from Mr. Caleb Smith of Kansas Appleseed. If we could have a little less levity. Thank you. Thanks, Mike. Caleb Smith of Kansas Appleseed Center for Law and Justice. His testimony didn't make it into testimony for HB 2585 the other day, and we were able to get it to committee members and made available his email address to address any questions they had for him. Apologies to Mr. Smith. I'd like to open the hearing for House Bill 2653, and it does have a fiscal note. I will turn over to Mike Heim for a brief review. Thank you, sir.
Mr. Members of the committee, this bill deals with basically requiring images of ballots counted by to be available within 48 hours after the close of the polls on Election Day. A candidate may request a digital copy of all ballot images for those ballots counted and included in the reported election results that were counted using electronic or electromechanical voting systems or optical scanning equipment. Any information shall be provided in digital format as prescribed by the Secretary of State. It allows for sorting of the ballots by images, except that any voting precinct having less than 20 ballots shall not be provided in terms of that form to protect the privacy of the voters. The provisions of the bill don't affect any county that does not use electronic or electromechanical voting systems or optical scanning equipment. Anyway, that's the bill.
Yes, Mike, I have a question from Representative Bourgeon.
Thank you, Mike. I was just curious, does this bill have a fiscal note? Who's picking up the cost of compiling all of these ballots?
I'm going to ask the research staff to check out the fiscal note. I didn't look for it, to tell you the truth.
You want to pause for a little bit? Or?
Yeah, they ought to be able to pull it up here in just a second.
Yes, ma'am.
Jessa Farmer, Legislative Research. According to the fiscal note, the Office of the Secretary of State indicates the costs associated with enactment of the bill could be absorbed within existing resources. The office indicates the bill would have a significant fiscal effect on county election offices from the cost to purchase and maintain voting equipment that produce a digital copy of ballot images. The cost to each county that currently does not have this type of equipment would vary depending on the population of each county and the number of devices needed to serve voters.
Just need to think about that. I'm just wondering if this is ever done on a statewide basis. I don't know. I question what the cost would be and what the impact would be for the counties, but maybe we'll hear from some of the other folks that are testifying. Thank you.
Thank you, Mr. Heim. And another question for Mr. Heim? Yes.
Thank you, Mr. Chair. Is this for all elections from statewide through school board, or does it specify specific elections?
It doesn't specify any, at this point in time, I'd interpret it to be all.
Thank you, Mr. Chair.
All right. Thank you, Mr. Hahn. We have proponents, a few. First proponent is the one presenting the bill, Representative Topikar. If you'd come to the mic, or, yeah, go to the microphone. And we'll have questions after the proponents.
Thank you, Mr. Chairman. First of all, I want to say that there's evidently some kind of a little glitch going on, because I had made arrangements earlier in the day that Reviser Jason Long would have the amendment that I had proposed to this bill up here. So if either the committee secretary or the other reviser could get a hold of Jason Long right now and get him to send the balloon amendment up here.
He'll take care of that.
Okay, thank you. But I'll go ahead and explain the purpose of this bill. And I know Reviser Heim already went through part of it. But what this bill is it's to bring, you have my testimony, I guess. Everybody has my testimony. Okay. But you heard that we're trying to get ballot images to the candidates. This is candidate only. I'm trying to get any candidate that was on the ballot in any committee, in any election, I'm sorry. And to answer Representative Adjourn's question, it would be any office, any candidate for any office in the state. And so what it would do is provide that candidate, if the candidate requests that they want to receive the ballot images. This would be the paper ballots, or in counties that have electronic machines that where you cast a ballot on a touch screen, you touch the screen, and then you take that paper ballot and inspect it. And if it's the correct candidates that you voted for, then you take it over to the tabulator and turn it into the tabulator, and then it records your vote. So it would take those, pictures of those, and pictures of the paper hand-voted ballots, the paper ballots, you know, that size of a ballot. And it would take pictures of both, and then it would make those available to any candidate that was on the ballot. And so the gist of the bill is to bring public confidence in results of elections. We've heard so much over the last couple of years about you know, not trusting vote totals anymore. I think this bill would help to rectify that problem and with public confidence. And if you can follow along in my testimony, you'll see that I'm talking about the tabulation and the counting process. It will all come out. You'll be able to take that, what the election office gives you on a little flash drive. You'll be able to take it home and just scroll through the ballots. And of course, all of us here know, or should know, since we've been involved in an election ourselves, that none of the ballots have anybody's name on them. They're all anonymous at this point in time. There's no identifying marks, no one's signature. And so all of these ballots are mixed together and no one can tell whose is whose, but you get them all on a flash drive and you'll be able to go through them all at home and count them, look at them, see all those. And then with the amendment that I'm bringing to this bill, I'll talk about that when it gets here, but that adds a little bit more to it so you can compare those ballot images to the results tape. So if you look around the country, what's going on, I did find Colorado is already doing this. An example is in Weld County, Colorado, and they have a website that anyone can register. I did it this morning just to test it out. I got on their website, and all you have to do is put in your email and a password, and you can, not even living in Colorado, you can get on and you can scroll through all of their ballot images and in any election in Weld County. And I gave you some hyperlinks there in the testimony if you want to click on those, and you can look at news reports of what this system does. It's, as technology advances, you'll see that you can filter right down to the ballot itself, and you can then, if you have any questions about the ballots, you can see for yourselves. You can compare them against the results tape, and hopefully that will alleviate anybody's concerns and build more trust in our elections, which, as we all know, we've kind of lost a little bit of trust in the last couple of years because of the media and other things out there, other issues that are going on with ballot boxes and everything. I mean, drop boxes and everything else. But I have done a lot of research on this, and I verified that clerks can download the images to this flash thumb or stick drive, whatever you want to call it. They can do this real rapidly. They could do it many times in an hour. And so, Mr. Chairman, I'll just cut this short, and I've given you a couple of links there. You can click on them and look at the news articles. They explain it. The media has written a couple stories here, and I thought I'd share those with you. But for these reasons and other, I ask the committee to support this bill favorably, and I'll offer the amendment when I get it. So.
Before you go, we might as well just go around and since you're the presenter of the bill, any questions, and starting with Jesse.
All right, thank you for the testimony. I just have kind of a logistical question, and that is if the request was being made in a statewide race, is that candidate, or are they required to make that request of all 105 counties? Is there some way to streamline that through the Secretary of State's office? I just don't see that being addressed in your bill.
Well, it's not addressed, and it is all 105 counties. So if you run for governor and you want, at the end of the election, you want to get the results in all 105 counties, and I doubt if that would happen, but if a candidate wanted to, they could put that request in to the every county election officer through email, probably, I would guess email. And then the respective clerks, county clerks would then start, they would have 3 days to come up with the ballot images. And of course, you'll see in the bill that it is all, as Revisor Heim said, that it is that the Secretary of State shall adopt rules and regs necessary to implement and administer the provisions of this. So that's pretty much covered, but Is that, may I ask, is that amendment still floating around somewhere, or does the committee have that proposed amendment? It is online, okay. I haven't gotten to it yet, but,
I have one more question now.
Okay.
From Representative Proctor.
Thank you, Mr. Chair. And thank you, Representative, for bringing this bill to us. I love the idea. I do have a question about why you chose 48 hours after the election day, because, ballots are still coming in for another day. Why not 72 hours, or why not after the canvass, but before the deadline to object?
right. And so exactly what's in the amendment, we changed that to 3 days. And so I'm trying to get the amendment up so that I could tell you better the exact language, but it is
You have
3
a
days.
follow-up question to that then?
Yeah, but would you object if the time was moved out to within 24 hours, 48 hours after the canvass? Because the feedback that I got, or that one of the representatives got when they talked to their clerk is like, I'm so darn busy, between the end of the election and the canvass, that this is a huge, huge logistical burden. But they've still got 5 days after the canvass to object. So would you consider that a hostile amendment if somebody were to make it 2 days after the canvass rather than 3 days after the election?
The original idea of the bill was to get it as soon as possible, to get it as early as possible. The sooner the better. So when the election's over at 7 o'clock, then a candidate could look at those ballots in a snapshot in time at that point. And so the candidate would know what happened on election night and be able to see for themselves what the ballots were, what the results tape that came off the same tabulator, what that showed. They could compare them. And what happens after the canvass is different because, of course, they're going to add the provisionals at that point, and that would skew this. And the original idea here was to see it as soon as a candidate could, to see if there was a red flag somewhere on one of the tabulators or touch screens, or in the smaller counties and any of the process that does use machines, then they could see it right then and there, within the first 3 days. And they'd be able to further plan, as you say, if they wanted to do a recount or a contest of the election. And they could do it at that point. But I would rather keep the bill as it is, and the sooner the better was the way that I thought it could be drafted. So,
Representative Neighbor.
Thank you, Mr. Chair. Just a couple questions, if I can. I think there's 3, if that's all right. Sure. The amount in the cost from the budget director, it said the cost would be could be contained in the offices except in county clerk's offices, because it would require a much higher amount for maintenance and purchase of necessary equipment to do this. So do you, first of all, do you know how much it would cost to bring each of the clerk's offices up to that level? The second part of that goes with that. Would there be a report charge to help offset the maintenance and equipment that would be required?
I would say, generally, to answer your question, first of all, I haven't seen that fiscal note. So there is a fiscal note out there?
It's online.
Okay, I haven't seen it. But I would say that part would be up to the Secretary of State. It's in the bill that the Secretary of State shall adopt the rules and regs, and of course, in talking to the election commissioners and county clerks, they would develop whatever fees need to be charged to cover costs and time. But the idea here is using technology. You have flash drives, thumb drives, whatever. You have the ability to get all this information out real fast.
And I understand the availability, but I think this is the cart before the horse unless we know how much this is going to cost each county clerk, because they said it was going to be a much higher cost. Where will that money come from? There's nothing in the bill that talks about the ability to collect for that information. And you were just recently talking about really getting this quickly, but that's only a partial story that you get. You don't get all that information until the canvass has been completed. So it doesn't give false information, but it may give false hope, because we've seen in some races where provision of votes and those kinds of things have changed that kind of information. So I think those are some things I have concerns about unless the balloon brings some definition to that, because undue costs on county clerks, we need to let them know what our expectation is and how they're going to pay for that. So thank you, and thank you, Mr. Chairman.
Is there any
I'll
more
try
questions? Did you think of anything else to ask? Okay, if not.
I kind of combined.
Mr. Chairman, if you didn't mind, I'll try to address just a couple of real quick. One is, it's not every county, and it's not every county clerk, because you'll see that that in paragraph D, the provisions of this section shall not apply to any county that does not use electronic or electromechanical voting systems or optical scanning equipment. So it wouldn't apply to every county. And only the counties that have the capability to do this. No, the Secretary of State office will tell you later that we don't know exactly how many, but we do know that there are some rural counties that cannot do this. And so, of course, in those, the candidates, this wouldn't apply to them. But as far as the, where's the money going to come from? That would be the cost factor in this. And I didn't see the fiscal note. And how much did you say that it was?
Sorry, may I answer, Mr. Chairman? The reviser had the budget amount or
The fiscal note?
the physical note in front of us?
Yes, ma'am.
Jessa Farmer, Legislative Research again. It didn't provide an exact number. It said the office indicates the bill would have a significant fiscal effect on county election offices from cost to purchase and maintain voting equipment that produce a digital copy. But it would vary on the population of the county and the number of the devices that they need.
Yes, so I agree to that, and I, as far as the appropriation needed to do this, I'm sure that that's subject to whatever we pass.
Thank you, Representative. Representative Smith and Representative Osman.
Thank you, Mr. Chair. Representative, are you just asking for a total from the precinct, or are you asking for every individual ballot?
That would be up to the candidate. Say you're in a race and it came down to 10 votes, you know, on the original canvas, and you would like to check out a couple of your precincts. So that would be up to you to put that in writing. None of this requires you, if you ask the election commissioner, your county clerk, none of it requires you to do your whole district. It's, you could zero it in down to one precinct if you wanted, and I'm sure that would be, you know, the cost factor would
Now,
be a lot
they all
lower.
come on email. There wouldn't be any paper going to the candidate. It'd be, all be on email.
No, there wouldn't be any paper going to the candidate. It would be on a flash drive or something to that
Right.
effect.
And
And
a lot
then,
of them are ballots are two-sided, so I mean, it'd be quite an operation to send that many.
right, but it's on a flash drive.
Okay.
So I've been told by those that do this that it wouldn't take hardly any time at all to put that on a flash drive in today's world. But Mr. Chairman, we haven't even gone through this balloon amendment yet. So did you want me to do that, or do you want the revisor to do it? I don't think the revisor has seen it until now, but I could go through it. Okay.
Pardon me, I'd like to get these initial questions laid out, and then if they relate to your amendment, then you can tell them that, and that you'll answer it soon. Mr. Representative Smith? Okay. Representative Osman and Representative Proctor.
Thank you, Mr. Chairman. So as far as I'm aware, we don't actually have any testimony from any county clerks today. So I'm going to ask you if you are aware. What is the actual process for scanning these ballots? I mean, do they physically scan every single ballot? And do you have any indication as to how much time that's going to take?
If you remember the other day, we kind of went through some of the mechanics. I think Representative Howell kind of described, described the exact process, the logistics, and it's different in every county. So I can't tell you exactly what every county would do, but I can tell you that the bigger counties with the more, the newest equipment have tabulators. And so you take your ballot from the touch screen, gives you your people that you voted for, your candidates on the ballot, and you take that to the tabulator, and then everything goes into the tabulator. And then that's where the flash drive comes into play, that everything is recorded into the tabulator. Tabulator has two components. One is everything goes onto a flash drive, and it records all the votes, all the, the handwritten ballots, and it records all the ones that you did on the touch screen. They're two different sizes. It records them all. And that's what you would get as a candidate if you requested it. And the other part of the tabulator is the long paper tape, like a grocery receipt tape that you get. Now, the candidate wouldn't get that, but those, according to this amendment, would be posted in the county clerk's office or the election office, election commissioner's office, and you could go in and, as a candidate, then you could inspect that tape and you get your results off that tape, and then you could compare it to the ballot images that you have
So, but
on the flash drive.
if I'm understanding, it goes into the machine and it records, it tallies up that vote, but does it actually take a scan of the individual ballot as it's going in? That you
My
can
understanding is that it
transfer that
does.
photo over to a flash drive?
Yes. My understanding is that's how it works.
Okay. I have one more question, if I can, and it may be to the revisor, it may be to anybody that knows, what is the length of time for a FOIA request, for a state agency to respond to a FOIA request?
Representative Lee, do you have
If
an
anybody
answer for that?
knows, yeah.
I was just told in committee yesterday, it was 3 days.
Okay.
I just had the committees folks, KAC, Kansas Association of Committees, told me it was 3 days.
3 business days then, okay.
3 business days to respond with the documents and materials?
Thank you, Representative Lee. Is that correct? Okay.
Well, actually, what I was told yesterday is 3 days to get back to you, and if they don't have all of that together yet, to be able to say in 3 days, hey, you know what, we don't have all this readily available. This was a local government issue. We don't have all this available, so we will get back with you. And then there's not a specific amount of time on when they need to get back to you, but they have to at least touch base with you in 3 days.
Now, Mr. Chairman,
Mr. Heim.
That, what was just said is correct. You're supposed to, if you can respond immediately, you're supposed to respond immediately and produce the records. If you've got 3 days, though, in order to give a reason if you can't. And then you've got to make a reasonable effort unless there's some reason why that's an exception to the open records or whatever, but you have to state the reason, or if you are going to provide the records, give them a time frame of when you will.
Okay. Thank you. That helps explain. I'm just concerned that does help explain it, and perhaps even the Balloon Amendment, I realize, would go to 3 days, but I wonder, because under a FOIA request, you're gathering information that your agency already has. This is brand new information, and with a FOIA request, you have 3 days or longer if you have a rational reason as to why. This would be mandating 2 to 3 days of brand new information to present out, and that seems a much stricter amount of time to respond to this request as opposed to any normal request.
if I can respond to that real quick. When you're talking about the FOIA, or the Freedom of Information, that's what you're talking about, the Kansas Open Records Act.
That's correct.
Okay. This bill is not drafted to be part of the Kansas Open Records Act. This bill is drafted that the legislature has the ability, with the intent that the legislature has the ability to make its own law concerning the inspection of copies of ballots. And so that's why, if you look at it, it doesn't put this in any section of the Kansas Open Records Act. You're right, it is new, but it's not any different than anything else that we offer the public that doesn't fall under the Kansas Open Records Act. So there's no restrictions.
You would recognize that it's actually a stricter situation than even the Open Records Act. It's asking for a stricter and a more prompt response than even the Open Records Act requires. Yeah.
Right, because it isn't drafted with any intent to apply to the
Sure.
open.
Thank you. Yes, that is my point. I realize that it's not directly under FOIA or Freedom of Information Act. It was just that this is a stricter application than FOIA would be. And the difference between the two is with FOIA, you are dealing with information that you already have available. You just need to search for it. This is brand new information that is coming in on election day that you then would have to gather within 2 business days to present back out to any candidate that requests it.
Yes, the counties that have the capability to do that do it all the time, because they do this anyway. We're just under the big balloon there, the big paragraph there, B, you'll see that the election officers are only asked to make one extra tape. So they produce the one tape from the tabulator, and all they're asked to do is to make one more, and that one would be available to the public.
Thank you, sir. Representative Proctor.
Thank you, Mr. Chair. And I'm glad that the previous representative went before me, because that's what I wanted to highlight. You know, when I first heard about this bill, I had this picture of a bunch of people furiously running ballots through scanners into the wee hours of the morning trying to meet this requirement. But your bill makes it clear that only counties that are already scanning those ballots as part of the election process are bound by this bill. And but the question I have, you've said it several times, I just want to make sure everybody in the committee hears it, you've talked to county clerks or election officers, and they have communicated to you that this is not a huge requirement.
No, I mean, if this was going to be a problem, I wouldn't be here right now. So I wouldn't be here with this, but this is very doable. And if you go into those hyperlinks that I gave you on my testimony, you'll see that it's happening across the country. And I gave you those 2 examples from Colorado.
Thank you, Mr. Chair. Thank you.
All right. Yes, Representative Dodson.
I just want to make sure procedurally that I'll have a chance to make some comments. I don't have any questions of the presenter.
In our deliberation.
Thanks.
Excuse me. Yes, you will. I just turned my microphone on. Thank you. All right. John, thank you very much. Our Representative
Mr. Chairman?
Hoppinger. I'm sorry. Yes, ma'am. One more question for the representative from Representative Howell.
Thank you. My first question may be better off directed to the reviser or research, but has the idea of giving this information, these photographs of the ballots, been checked against federal election law?
We can check on that. I'm not familiar with, I mean, you can't disclose who voted and how they voted, but in terms of the ballot itself, as long as it's not revealing who voted, we could check on the federal election law. Off the top of my head, I don't have a clue.
We should be receiving some comment and maybe get question time with the Secretary of State's office. So, all right. And yes, ma'am, one more.
Then I had 2 questions, if that's okay. One is, I am a little bit curious, why did you write this law so that only the candidates had access to this and not the public?
I drafted it like this to start with because the first reason is that we don't do this yet in Kansas. And so I thought the best way to do it would be to apply it to candidates only. And the most workable, because we've already heard discussion about how it might be a new thing for clerks, and some of them might be hurried and whatever else was said that. So I decided to draft it to only apply to candidates, but I'm sure that in the future it could be expanded. Like, for example, Colorado lets any citizen get online, and they post it online. They post all these ballot images online, and then any citizen can get on and view all of this information. That's why I wrote it like that to begin.
All right, and then my last question is, since this is 3 days after the election day and not after canvassing, then that would mean that the data that the candidate receives will absolutely be an incomplete total, because it will not include the mail-in ballots that have already been turned into the election office. It will not include the mail-in ballots that are being dropped off at the poll sites that day, throughout the day, and it will not include any paper provisional ballots just off the top of my head, will not be included in those. And then, of course, when it goes through the Board of Canvassers, a number of these ballots will be rejected.
Right.
Because of various reasons. So the candidate would only have access to information that is incomplete and has an inaccurate total. And I'm just wondering how you think this is going to help avoid confusion for the candidate, and how it would actually be helpful for them when they don't actually have accurate data in it.
I wouldn't necessarily say that the information would be inaccurate. because well, it's not, this isn't drafted to include the provisionals. So, or anything that comes in after Election Day. So this, and I've cited the, you'll have in your testimony, I've cited the statutes of the original canvass, and you'll see that provision of the law.
And I really appreciate the questions that are going on. Some of these questions will be also beneficial and more beneficial during our deliberation of whether to pass this out. And nothing against anything that's been said. We have some other testimonies that have come to share with us, and hopefully after we work these other bills that we've worked previously, after this hearing, then we, if we have time, we will try to work this bill. And
Thank you, Mr.
thank you all representatives, and we'll look forward to these same comments in a little bit. Next, we have Missy Levitt, citizen on WebEx. Are you here, Missy?
I am. Thank you so much, Mr. Chairman. Can you guys hear me okay?
Yes.
Okay, so thank you, committee, for allowing me to speak again today. I would like to stand as a proponent for this bill. This bill opens up transparency a lot. I did offer a consideration for amendment that hopefully everyone has a copy of. And basically, I just think that the candidate portion should be changed so it's to the public. And also to add what we call cast vote records to this. Cast vote records are a record that is held within the machine once the ballots are tabulated, and they are what is calculating the tape that prints out from the tabulator. And these cast vote records will actually give you the precinct breakdowns as far as what machine they came from and that nature. So that would be very helpful as far as that goes. I would like to address some of your guys' concerns as far as fiscal notes. The secretary.
Is this part of your presented testimony?
Oh, I'm sorry. Well, I can say that, you know, it's not, I apologize. But as far as cast vote records, I'll just explain. When a ballot is put into a tabulator, there is a scanner in there which makes a copy of the front and the back of the ballots. And that only happens in a Generation 2 tabulator. Those are not everywhere. So this would only apply to the counties that have a Generation 2 or earlier version, to be quite frank, of tabulator. So those images are created immediately inside of the tabulator, and it should only have to be removed and a copy made and supplied. What I can say as far as that goes is even the requesting part of this bill might add some time for the clerks, but I don't know if it's an option or consideration for someone to just post it online to save the clerks from having to respond to specific requests. As far as the cast vote record, it is then automatically created inside of the tabulator as well. This would not be new things that the clerks have to do. They just extract those files and make copies of them, like with a thumb drive, just like Representative Topiker is saying. So this really should be very, very simply done. That's kind of the part of technology that everybody enjoys, is the quick and easy access to files and transferring of them. So basically, excuse me, both records are already created within the tabulator, but I do believe that the public should be open to these as well. There is also, I would like to make note to you all that in statute 254611 under section E, it already says that upon completion of the count of returns, they shall be open to the public. So we already have this wording in other statutes, but what's produced by the tabulators should definitely be the same, in my personal opinion. I really don't have anything else. I don't want to go off topic, but I can answer a lot of questions in regards to this. So if anyone has any concerns, but I I can add those if anybody would like to ask. Thank you.
Thank you, ma'am. You have a question?
Thank you, Mr. Chairman. I just wanted to get clarification. We have you listed as an opponent, but I thought I heard you say you were a proponent.
No, she's listed as a proponent.
Oh, I must have an old copy. My apologies, Mr. Chairman.
And thank you very much, ma'am. And we will move on to a testimony that is on video that's going to be presented to us on the screen from Tammy Davis, a Johnson County resident. And if you can try that, I think the sound is pretty limited, so listen carefully and we'll see what happens. Also a proponent.
Hello, Mr. Chairman and committee members. First, I want to thank you for your work to make Kansas great. My name is Tammy Davis, and I'm a resident of Johnson County. I want to bring to your attention HB 2653. While it is important ballot images are provided upon request, this bill falls short of meeting the requirements set by the Open Records Act. KSA 45-216 states public policy that records be open. It's declared to be the public policy of the state that public records shall be open for inspection by any person unless otherwise provided by this act, and this act shall be liberally construed and applied to promote such policy. Frankly, we shouldn't even need HB 2653 because public records of an election should already be able to be requested by the public. However, to further this specific public records bill, increase confidence and transparency, and to align with the Open Records Act, I support the requested amendment by Missy Levitt. A few important details of that amendment include that the bill be for anyone in the public, not just a candidate, and it should include the cast vote records along with the ballot images. So again, thank you for your work and your time and your consideration. Have a good day.
Yeah, you can ask. And our thanks to Tammy Davis for her testimony, and I don't believe she's online with us, but was everybody able to hear that pretty good? Okay. All right. Next up, we have under opponents, we have Davis Hammett of Loud Light Civic Action. And Davis, you're on.
Thank you, Mr. Chairman. Chairman Bergquist, members of the committee. There's a lot we could discuss about this bill. As someone who's been in lots of litigation around open records related to elections, this is an issue that touches on things that are very near and dear to me. I actually agree with some of what the two previous proponents said, that these records should either be open or not open. I do not believe that Kansas should engage in the practice of creating special record requests for candidates. Either they are publicly available records regulated by CORA or they are not. Also, I bring that up because I've been through these issues related to some county misunderstandings of the audit implementation, where I was trying to observe audits and they were like, what party or what candidate are you with? And then I'm like, I'm not a candidate, I'm a member of the public, I'm trying to observe. And they're like, you have to be with the candidate. And then I was like, no, trust me, you don't. This is a bill that I helped push. But anyway, so yeah, either things should be open or not. So if you are going to move forward this, you should make it regulated under CORA, accessible to the entire public. There are some technical issues with this bill, though, and I don't think counties are presenting. But for example, these scanning machines, it varies on if they can produce these images or not. Yes, the newer machines do produce these images while they are scanning them, but older machines don't. And I don't have the amendment before me, but in the current version of the bill, it just says if you have this scanning equipment, you have to produce the images. Well, the scanning equipment isn't producing the images in older equipment. Also, this doesn't have any sort of cost provision. So you have a situation where when the public requests records, sometimes counties ask them for hundreds or thousands of dollars, but a candidate could essentially request something that might take who knows how many hours of labor and get these documents for free. There's also a concern about if a candidate requests them, then both candidates should get the records, right? I mean, frankly, if these records are produced, they should be accessible to everyone because we don't want a scenario where a bad actor candidate requests these documents and manipulates the images and then tries to post them saying, oh, look, fraud, fraud, this happened, and other people can't readily fact check that person to say, oh, they've manipulated the images. Again, I think this has been discussed and maybe it's addressed in Representative Toplicker's amendment. But the 48 hours, it's kind of unclear how that works or how a county would produce these that quickly, because also even the counties that do have machines that scan these as they're being processed, these are very, very big files. I mean, you're talking about, for example, in Johnson County, you're talking about over 300,000 PDFs compiled that are large, high quality image files that it's not, I mean, just transferring that data, even if it is onto a jump stick, can be very labor intensive, but it depends on their sorting software. I mean, there's so much more. It's not like these images are just all of a sudden in a file that you just copy and paste and send over. There's a variety of different software that even stores them. How accessible it is varies. I would just kind of like ask that y'all really establish what you're trying to do with this bill, and then you work back from there. Because as this is written, even if you produce these results, they wouldn't be accurate. They would just show you a snapshot of a portion of the ballots. You're excluding precincts with less than 20 people. Well, that means that the results, you know, are going to be off. And there's a privacy concern, a very big privacy concern related why that provision's in there. But you're excluding provisionals, other things. When we talked about some of the confusion, a lot of the misinformation and kind of propaganda out there comes from a lack of public understanding of the process. And in this bill, if it's really not tweaked, I think it will actually like exacerbate the ability for that misinformation to catch fire and spread. So again, I think that this is headed in the right direction. I do know Colorado has started to implement these things, make them publicly available. But I think there's a lot of tweaking that needs to be done before this committee can move this out. And frankly, there's so many logistical concerns. I don't know if it's tweaking that y'all will be able to do today. I think it's something you might, you know, want to get essentially an interim committee with county clerks to make sure that you're really getting what you're after. Because I think if y'all push this out, you're not going to get what you're after. So thank you so much. I'm happy to stand for questions when appropriate.
Thank you for bringing your testimony. And is there any questions immediately for Mr. Hammett? Yes, Representative Miller.
Thank you, Mr. Chairman. I don't have a question, but I wanted to alert Mr. Hammett that I forwarded the amendment to your email while you were testifying.
Thank you, Representative. I appreciate that.
All right. Now we'll go to neutral testimony from presented by Clay Barker, Deputy Assistant Secretary of State, General Counsel. Thank you, sir.
Thank you, Mr. Chair. Clay Barker, General Counsel, Kansas Secretary of State. Since this bill doesn't affect our office directly, we never touch ballots or have scans, we're neutral on it. And I wanted to give a little background to help the committee understand it. And before I do, I've received several texts saying, if the committee is going to work this bill, it really needs to have some county election officers here to explain their internal process. People can throw around acronyms and technology, but you need to talk to the people that actually do this to understand it. And I'm not sure if they're testifying today or not, but to get on with my testimony, ballot images or scans is a relatively new technology, and a new technology combined with elections causes legal issues. Just as it's testified before, the counties in Kansas all have tabulators, but only a minority of them are able to produce ballot images or scans. And this is where the fiscal note gets a little confusing. We've finally talked to all the vendors, as I think this morning. It would cost the average county between $2,000 and $15,000 to upgrade their technology to create scans. Then they would have to pay an annual fee to maintain that technology. And if there's a problem with it, the larger counties have an IT person on staff that can handle it. The smaller ones don't and have to use the vendor to do it. And those guys charge fees that are almost lawyer fees, which is why sometimes on election night, if you see that small rural county out west, it's taken so long to report its numbers. That's because their tabulator broke down. No one could fix it, and they had to hand count the ballots. And it could drag on until Thursday or Friday. Scans are already incorporated in the audit regulations from our office. A county is able to use scans compared to the tabulator or the actual paper ballot. So you put the scan up and 3 people look at it and go, agree, that's who that vote was for. Now, it is a national issue whether ballot scans are subject to open records laws. And that's why some states are passing laws about it right now. This is what it looks like from a county election officer legal standpoint. And I get questions from county lawyers about this, and I tell them, I can't give you legal advice. I will give you the raw materials, and you can advise your county. Statute 2708 says that election workers are only allowed to give ballots to the canvass, and once the canvass is closed, those things are sealed up and secured, and then only under court order, so nobody can touch them or look at them after the canvass. 252422, it is a felony to allow anyone to see the contents of a ballot. And that's what scares the county election officers. They don't know if an image is considered to be a ballot or not. There's one Kansas case law that came out of Sedgwick County a couple years ago when somebody wanted to look at the paper to do an audit and went to the Kansas Appellate Court, and their reasoning was ballots and related materials are not subject to KORA. They're outside the Open Records Act. They're part of election world, not open records. Therefore, KORA does not apply, and her request was denied. And a recent New York Supreme Court case used the same logic to say no one is allowed to get ballot images under an Open Records Act. The legislature has to change the law and make it clear whether they are subject to the public or not, which is why I believe this bill doesn't even mention KORA. It sets out its own distinct requirements for these. And in case anyone was wondering, the reason that there's an exclusion for a precinct with 20 people or less, there's another statute, 2701, that requires if a precinct has 20 votes or less, its results are always merged with a larger neighboring precinct, so you hide the identity of those voters. You can't go in there and say, oh, 5 votes for Trump or Biden, and I know who voted, therefore I know how they voted. That's where the 20 comes from, which makes it a little more difficult to get the by precinct. That would be harder for some counties than others, and that's incorporated in the bill also. And Mr. Chair, that's all the testimony I have. I was just trying to give everyone a little background on this. It is a national issue, and hopefully the legislature, if not this year, will resolve it for the counties, whether they can give up these images or not.
Representative Proctor, you have a question for Mr. Barker?
I do. Thank you, Mr. Chair. I think it's under UACAVA that that military service members can vote by email if they surrender their right to privacy of their vote. Do you have any idea how prevalent that is in Kansas? How many ballots a cycle we get from that?
It's quite rare, but there are some. The UACAVA voters, if they sign a statement saying, I realize I'm giving up my ballot secrecy rights, can send it in multiple different ways, but that's fairly rare. But that's really for emergencies, someone in a forward operating base somewhere wanted to vote.
Thank you, Mr. Chair.
Representative Bourgeon.
Thank you, Mr. Barker, for being here. Thank you, Mr. Chairman. My question is, you're looking at these other states that are implementing or taking some action in this area. Is it consistent with the time frame that we're looking at, or are they waiting to release those ballots until the results of the election are official and have been certified?
Representative, I can't answer that question right now, but I do get a list every week of every bill in every state on election law, and I can look it up and see what they're doing. But I think to Representative Toplicher's point before, each county has somewhat different processes, so when you get these results, there probably have to be a large disclaimer on it saying this is not the final count. We don't have provisional ballots because they're not scanned until the canvas says to go ahead and scan them. Some counties may deal with write-in ballots differently. If the tabulator rejects a ballot, whether it's scanned or not is different by how the county does its procedures. So we'd have to say this is not a complete picture of all the ballots. It's an in process. So I don't know about the days. If you're saying I need 48 hours, you probably won't get them all, or whatever the amendment says.
Thank you, Mr. Chairman. I just wanted to augment the question that Representative Proctor asked. Military ballots can also be cast by fax. And once I represented a woman who, after the canvass, was tied with her opponent until they discovered that they had not counted a military faxed ballot, and she lost by 1 vote.
Oh.
Representative Lee.
Thank you, Mr. Chair. Clay, why, I guess I'm struggling to understand why these ballots, are so private if there's no identifying information. To me, this just seems commonsensical that we just have transparency. So what do you see in terms of a downside? I don't even understand this Sedgwick County case. If there was no identifying information to these images of these ballots, what's wrong with having them open to the public to see, just as another layer of protection to the public that the election was fair? Help me understand the problem here.
Representative, you question right on. And we're not discussing the policy of whether the ballot should be let out or not. Like you pointed out, there's nothing on the image that indicates who cast the vote or how. I guess in old school paper ballots, people used to exchange money if you put a mark on the back of the ballot and they could see how you voted. But I don't think that would come up today. It's just that the county election officers, they don't know what they're supposed to do. Is a ballot image more like a ballot where the law says you can't let it out? Or should it be subject to open records in anyone or whatever the law says? So they're kind of stuck, and they see that felony statute there, and they don't know what to do, and they're just asking for guidance.
So this particular, if I might, Mr. Chair, so this particular piece of legislation then would give the green light to these county clerks that indeed they would be off the hook when those images are put online that have no identifying information for the public to see each of these ballots. That would alleviate that, correct? This particular piece of legislation.
That's why I think we're seeing bills in other states, as county clerks in other states are having the same issue. They don't know which way to go, and they want guidance from the legislature. Like I said, it's a newer technology, and it brings up new issues.
And then I guess, last question, Mr. Chair, if I might. So in terms of these machines, I think we've heard from the Secretary of State's office, I believe it was last year, that each county clerk's office is given a list of the machines that they can purchase or lease, because they don't own them, right? They lease them, or both, either?
Lease or purchase.
Okay. And so I would assume that the newer technology machines then would have the capability of doing the image. Is that correct or not correct? I don't know.
Generally, yes. You have some options on what you want in your equipment, and each county can negotiate a little, but the newer ones almost all have this capability built in.
So when that ballot goes in, it's automatically taking a picture of it anyway?
It's just part of the process. So you're not scanning ballots. It's just when you put it in the tabulator, it's incredibly fast, but it counts, scans, moves on.
Okay. So that seems pretty streamlined to me. I just want to make sure I understand that it does it all the same. The county clerk doesn't have to go back and make another image, and it all happens in one swoop when that ballot goes in.
Yes.
Correct. Okay, perfect. Thank you so much.
Again,
Sorry.
That's the way I understand it, but I would encourage you to actually get a real county election official here to make sure what I'm saying is correct.
Sure.
And if I could answer Representative Howell's question, there is no
That's fine.
conflict with federal law on this.
Thank you. Representative Topniker and then Representative Proctor.
Mr. Chairman, we've heard the question around the committee, why is this bill drafted for that snapshot in time? And why don't we wait until after the canvass and include the provisionals and everything else that the Board of County Canvassers would decide later on? And I mentioned earlier that it was because we wanted to see what happened election night. And this is covered in 253006. It's called the original canvas. It's what the clerks sign, the piece of tape that comes out of the tabulator on election night. And that is a break right there in time in the election. And that's what this bill is drafted to address.
Thank you. Representative Proctor and then Representative Howell.
Thank you, Mr. Chair, and I'll be brief. The way the bill is written right now doesn't make a distinction between machines that do and machines that don't record an image. Is that correct?
Representative, that's the way I read it. Representative Topliker thought it did, and I would just.
Great. Then my follow-up to that is, if this does compel even those clerks that don't have the newer machines that make a scanned image, is it even possible to comply with this? Because my understanding is it requires a court order to open up the machine and get the ballots out.
If the machine can't make scans, then they can't produce scans of the ballots.
Okay.
The tabulator just counts the ballots and then that's it.
But am I correct that they couldn't take the ballots out of that machine to do the scans manually, even without a court order? Is that correct?
I believe that's correct, because only election workers are supposed to touch the ballots, and they're preparing them for the canvass, and they're secured. So I don't think they'd be able to take them out and separately scan them.
Okay. Thank you, Mr. Chair.
Representative Howell.
Thank you, Chairman, and thank you. I'm a little bit confused on a couple of points. Do you have a copy of the amendment yourself, by the way?
Yes.
So I'm looking at the amendment, and it says under section B, it says, each county election office shall print 2 copies of the voting result details report for each tabulation machine used in each voting precinct, et cetera. Okay. So that means the ballots are going to go from the tabulator to the election office. And then after arriving at the election office, then these 2 copies of the voting result details will be printed there at that point. Am I reading that correctly? Am I understanding that correctly?
Representative, that's the way I read it. This is the first time I've seen this, but Representative Topliker probably knows the amendment better than I do.
All right.
First time I've read it.
And then my other question would be, in the very next sentence, it says each report shall be signed by the election judge and the election board. Does that mean the supervising judge and the poll workers? Or does that mean, I don't know who the election judge could be inside the county election office? Or I'm unsure who they are, because I'm a little confused by this, because only the supervising judge goes back to the election office at the end of the election day. Not all the poll workers do not go back to the election office after the election is over. So at the end of the day. So if that does mean supervising judge and poll workers, if that's what the term election board is supposed to mean, they would not be present at the election office to sign this print off. So I just have questions about that, and if you don't know the answer, that's fine. But.
I think Representative Topliker is trying to provide some clarity on this issue, if we can yield to him.
Absolutely.
Yes, that is current law, that they do have to sign those tapes there at the precinct. And it's current law. You could probably find it in, like I said, 253006, and then in that area of the law, it's all spelled out right there. But it's current law that they have to sign those tapes, those paper tapes.
Okay, then so what you actually intend for this amendment to be is, instead of at the county election office, they would actually do this at the poll site. Am I understanding that correctly?
That's my intent.
Okay.
I think that's.
So that might need to be changed. And then I just honestly do not remember if the tabulators print off paper, but I bow to your research on that. Then my other question, which again, maybe it is for the representative, and I apologize. It appears to me on line 18, it says shall not be provided to protect the privacy, or I'm sorry, let me back up just a little bit more. It says, except that any voting precinct having less than 20 ballot images shall not be provided to protect the privacy of the voters in each precinct. And then down under section B, it says one report shall be maintained by the county election office as an election record. My question would be, if we're printing that report directly from the tabulator, then we would have to alter that report to block out the precincts that have less than 20 or something. So the report that's being released, I guess, to the public or for candidates to see, I'm not quite sure on that part, would not be an unaltered report. Am I understanding that correctly?
John, Representative Topiker.
It would be my interpretation is that of the law is that it would be an unaltered report because each precinct is separate. And if you had a precinct less than 20, you just wouldn't do the report. You wouldn't do that one. So you wouldn't have to alter anything. It just wouldn't be provided. It says in here that it shall not be provided.
Yes, ma'am.
And Chairman, if this is not appropriate, then just please do say so. I would just say that looking at this, I have enough questions that I would really feel better if we had a couple of different county election clerks or election commissioners from different counties to discuss their procedures and how this really works in the real world, because I have a lot of questions.
Thank you, Representative Howell. After we close this hearing and after we work through these other bills, we'll consider those motions in the process of dispositioning this bill, and we'll do that as time allows in a little bit. And one more question from Representative Lee to Mr. Barker.
Thank you, Mr. Chair. Quick question. Is there a rule on how old the machines can be for the counties? Is it like you can only have a machine that's 5 years old? Or, I mean, do we have a rule like that? Or are some of these machines 20 years old, these tabulator machines or election?
Don't know how old the oldest ones are. There's no rule on age, but if there's a major upgrade, it has to be recertified.
Okay, so some machines could be 20 years old and some could be 2 years old.
As far as I know, they could be. I just don't know how old.
Okay, so there's no rules regarding it, though. Okay, and then just one more thing in those machines. Is the tabulator tape public record that Representative Howe was talking about?
I don't remember, but I've been in the polling places where the supervising judge pulls it out and reads everyone the results, but then takes it back to the county. So if obviously public record. I don't know if the tape itself is.
Okay, I just didn't know if they wanted to look at the actual tabulator tape, if that was allowed or not allowed. I just didn't know. They do that all the time?
And it really does relate to whether you're duly authorized to be there on the spot when that happens, and then you can be the observer of what's being read off, and you can hear what's being read off of that tape. So it's a matter of your presence, not at this point, not of anything else.
So if someone wanted to see it 2 weeks later, though, that you can't, just right then?
I know no reason why you couldn't see it later, no, but you certainly can see it immediately. If you carry the proper credentials, which doesn't take any magic. You just have to apply for those credentials. You get them, you go to the polls, collect the results. You just inform the judge you're there to collect results. When they pull out the tape, they let you look at it.
And then they save it?
They take it in, they take it back to the central office, and that's what they report.
Got it. Thank you very much.
We'll get you an answer on that, Representative Lee. Like Representative Miller said, you're a poll agent. You can see the tape, you can read the tape, but usually the judge has it in their hands. Takes
Great.
it back with
I'm sure that Vic isn't wrong, though. I'm sure he's totally. Thank you very much.
Thank you, Mr. Barker, and thanks to all the conferees who came, proponent, opponent, and neutral towards this hearing. We're going to close the hearing on HB 2653, and we will move on to possible action on previously heard bills. And we'll confer more on the discussions that were made over more information on this bill that just closed on hearing. But now we'll move on to final action on HB 2486, which is providing for the use of electronic poll books in elections and approval of such books by the Secretary of State, making fraudulent use of electronic poll books a crime, prohibiting electronic voting systems and electronic poll books from having the capability of connecting with the internet, requiring election judges to check for any such connection, and providing a deadline for post-election voting equipment testing and for notice of such testing on county websites. Just for a refresher, Representative Proctor, since you presented this bill, would you like to come to the microphone and share any comments you might have going into any amendments or anything else? And just for the committee to keep in mind, it's about 12 till the hour of 5, and however much your time you want to be yours, keep your comments the way you want them.
Thank you, Mr. Chair. You did a great job. The title, I think, says it all. This bill does three things. It makes it illegal to use or purchase voting machines that connect to the internet. It and requires the election judge to certify on election day that the machine's not connected to the internet. And I have a amendment, if it's the pleasure of the committee, that would strip that out, because we discussed during the hearing that how would he know if it connects or not. The next thing that this bill does is it creates a deadline of 5 days after the canvass for the second verification of the voting machines that they're in proper order, so that if there's going to be a contest of the election, that check has happened within the deadline for a candidate to contest the election. The final thing that this bill does is it gives the Secretary of State's office the authority to regulate electronic poll books, the list at every polling location of who is authorized to vote at that polling location. They're in use right now, but they're unregulated. But I've gotten a bunch of feedback about that from my district and from outside my district, and so I have another amendment that would strip that out that I'll present to the committee for your consideration, so that as a body we can decide whether we want that to go forward with this legislation or if we want to consider that at a later time.
And as a matter of form to the bill that was presented, I would ask, is there a motion to move this bill out as is for consideration on the House floor? Yes, ma'am. Representative Neighbor.
Thank you, Mr. Chair. I would move passage of House Bill 2486 as it presently was presented.
Is there a second for discussion? And then we'll be working with others. Representative Bourgeon. That is a second. So now for discussion and for any reason why or why not to move it out. So Representative Proctor and then Representative Lee.
Thank you, Mr. Chair. I do have an amendment. Okay. I believe Revisor Heim has already handed out the first amendment. It's short. All it does is on the first page in the title, and then in the body of the bill, Section 9, Item C, it removes the requirement for election judges to certify that the voting machines are not connected to the internet, because how exactly would they do that, which came up in the hearing.
All right, there's been a motion and a second to move it out, and there's now been an amendment presented. Procedure? What's the procedure for us to move forward on that? Consider the amendment straight up.
I think I need a second on my amendment, Mr. Chair.
Have a second by Representative Bourgeon. Any questions for Representative Proctor, Representative Topiker, and then Representative Miller?
Yes, I do, Mr. Chairman. I brought this up in committee when the bill came up the first time, that maybe it shouldn't be on the election judge, but maybe it should be on the Secretary of State's office to provide someone that could do that, some person of expertise that could do that. And so that's all I would say, and I would ask the carrier of the amendment, Mr. Chairman, whose responsibility should it be if it's not the judge?
And the carrier presents a bill that has no responsibility stated. It's not a matter of whether, but there is no responsibility stated for that portion. Isn't that correct?
Yes, Mr. Chair. And the reviser, please rescue me if I butcher this, but my understanding is that the cited statute already gives the Secretary of State's office the authority to make a list of authorized voting equipment that can be used in the state of Kansas. What this bill does is add the requirement that any voting machine on that list not be able to connect to the internet, and that it couldn't be purchased or used in the state of Kansas. Thank you, Mr. Chair.
Representative Lee? I'm sorry, Representative Miller and then Representative Lee, excuse me.
Yeah, really.
You're welcome.
First, a short question. This bill, I see that it's sponsored by two representatives, but it's actually was the bill that was requested by the Secretary of State. And secondly, I would just speak in favor of the amendment. I don't think this requirement of checking is necessary, given that just before that it says the Secretary will not even allow equipment that's capable of connectivity. So to me, it's pointless to check. Thank you.
Okay. And Representative Lee, and then Representative Lee.
Okay, thank you, Mr. Chair. So I just want to make sure, because I've actually had folks that have been working at these polls send me screenshots on their phones of internet connections that are available, Wi-Fi connections that are available when they're there. So this particular, as it stands right now, these machines are not ever supposed to be connected to the internet. That's what's in current statute?
Thank you for the question, Representative. Right now, there is nothing in statute that says that a voting machine can't be connected to the internet. This bill, if the body passes it out and it becomes a law, would be the first statute that makes it illegal to use or purchase a voting machine that connects to the internet. Right now, there's no statute that says you couldn't do that.
So, and this amendment then, we're not dealing with the poll books. This amendment then does, tell me what this amendment does.
So all this, there was three elements of this piece of the bill. The first is that you couldn't use the machine that connects to the internet. Second was that you couldn't purchase a machine that connects to the internet. But the third piece of this was that the election judge on election day had to sign off, certify that that was the case, that the machine didn't connect to the internet. And during the hearings, it came up that that's really, that guy's not an IT specialist and he can't open the machine because the machine's sealed. So there's really no way for him. So we're asking him to sign his life away without, yeah. Thank you.
So this is not, so the poll books is your next amendment. All right, got it. Perfect, thanks.
Okay, so right now we have an amendment to remove, to remove the requirement of the poll judge to certify. And that's all we're doing is amending the base bill. Representative Collins.
Thank you, Mr. Chair. I just want to make a comment on that. If the machine or poll book is, or I guess not poll book, but if the machine, voting machine, doesn't have internet capabilities when it's purchased, and like I mentioned in here a few days ago, that machine is sealed, you know, at that time, then if the poll judge just looked and saw that the seal wasn't broken, I think that would be a pretty good indication that it was not internet capable at that time. And I think that even with this, amendment, that would still be an adequate inspection, I think. Thank you.
All right. Any other questions pertaining to the amendment to the bill, not to the bill itself? Okay. Entertain, and has there been a motion and a second? Representative Proctor and Representative Bourgeon, motion and second to approve this amendment. Are you ready for a vote?
Mr. Chair, I close on my amendment.
All right. If so, all in favor, say aye.
Aye.
All opposed? Abstain, and the motion passes unanimous. Okay. Now we're back on the bill. Representative Proctor.
Thank you, Mr. Chair. I have a second amendment, if the revisor could hand it out, please. And I'll talk about it while it's being handed out. As the representative from Topeka said, I was asked to carry this or to sponsor this bill by the Secretary of State's office. And when I looked at it, I pretty much agreed with everything that was in it. And so I didn't see any issue with bundling it all together like this. After we had the hearing, I got a lot of feedback from a lot of people in my district that I trust and respect. And they are very concerned about the electronic poll book portion of this. And so to respect the wishes of the folks in my district, I'm proposing this amendment to strip that out of this bill. So what this amendment does is it removes all references to electronic poll books in the amendment. What this amendment does not do is do away with electronic poll books. And I want to make that very clear. Right now, polling places are using electronic poll books. This amendment would do nothing to change that. What this amendment does do is strip the language from this bill that would authorize the Secretary of State's office to regulate poll books. God willing, at some future period in the next session, we can do a bill just on that topic and have an intensive hearing on just that topic, because the concerns that I heard from my constituents, and maybe a few of you also heard, convinced me that it probably does deserve its own hearing and its own legislation. And so I stand for questions on this amendment.
Is there a second for Representative Proctor's motion? Been seconded for discussion. Anyone for discussion? Representative Miller.
We had a full hearing on this bill, and maybe I'm wrong, but I don't recall any opposition testimony objecting to this language. And as I remember, the Secretary of State's office was speaking highly of these systems and how much more efficient they make election day. So without seeing these supposed emails that the representative's been overwhelmed with, and see what their objections are, I don't know that I can support the amendment.
Anyone else? Representative Dodson.
Yes, thanks, Mr. Chair. The offer of the amendment is my office mate, my friend. But I must say that the Secretary of State's office did a good job in providing rationale why this was essential to the bill. we're going to worry about voting machines, we need to worry about the poll books as well. So we need to give them authority in order to operate. So I would oppose the amendment.
Representative Osman?
Thank you, Mr. Chair. It's difficult to rush through all of this to try to figure out exactly what's been modified. But as I see it, as I understand it, it looks like all applications of poll book has been taken away, but then we also have additions on here of no component of electromagnetic voting systems have been added in on page 3(2)E, under section 3. And I'm just wondering, again, having 30 seconds to look at this, does that fundamentally alter the nature of the original bill as we're trying to insert new language into this?
Representative Miller? Then I have a comment.
I think you're misreading the balloon. That language on page 3 that you said appeared to have been added is in the original bill. If it was being added now, it would be in a balloon out to the side.
Okay, so what the italicized portions?
Those are amendments to current law that are crafted in the original bill.
Got it, okay.
I just want to state that I believe that the representative bringing the amendment is I certainly believe he's doing it in good faith to constituents who have brought this concern. I think it disassembles this bill and causes more questions and more difficulties statewide than it does maybe bring solutions at this time. A lot of the concerns that have been brought up so far in this year and last year that I've been in committee bring more questions, not all solid answers. And that's why this is a science to itself for us as a committee to learn more and more about. And no one answer may give all of what we need to know. I will be opposing this amendment simply because I think it does too much to the base bill compared to what we're trying to accomplish. So, thank you. Anyone else? Representative Howell.
Thank you, Chairman. So could you, these concerns you've heard from some of your constituents, are these people such as county clerks, those type of people, or are these average voters?
Thank you for the question, Representative. The concerns that I've received have been from constituents that are not all involved with the voting process. Some of them have actually volunteered as poll workers. Some of them have not, and they're very varied. They're everywhere from we should be going back to paper poll books, which I would think is probably unworkable in the modern world, to people who would like us to put more guardrails in place, to kind of the same concern that we heard when we heard the constitutional amendment yesterday, that just giving carte blanche to any state agency to develop regulation that's on its own without any more specifics, they were concerned about that. And so I appreciate the chairman's words. I did bring this in good faith to represent my district, but to my office mate and friend, the representative from Manhattan, if it's the will of this committee that this remain in, I'll still support the legislation. But I felt I owed it to my constituents to bring these concerns to you and let you make the decision as a body before we take this forward. Thank you, Mr. Chair.
Thank you, sir. Anyone else before we take a vote? Before we take a vote on the amendment?
Mr. Chair, I close on my amendment.
Okay. Representative Proctor closes on the amendment. On the amendment specifically removing these items, all in favor say aye. Aye. All opposed? No.
No.
It appears the ayes have it, or the noes have it. Okay, and that's a recorded vote for Representative Proctor. All right, and we're back on the bill. Is there any other amendments? Representative Miller.
Not an amendment, but a motion. I move that House Bill number 2486 as amended be recommended favorably for passage.
Seconded by Representative Topiker. All in favor? Say aye.
I need to close.
Would you like to close?
Yes, I would say that, like many of Representative Proctor's constituents, I too am suspicious of any bill that has his name on it. Nonetheless, I applaud him for what he's introduced and amended, and stand in full support of it. Thank you.
All right. All in favor of the motion, say aye.
Aye.
All opposed? Abstain? And it passes. We'll move on to House Bill number 2555, requiring the county election officer to send a confirmation of address when there is no election-related activity for any 4 calendar year period. Do I hear a motion? Representative Neighbor?
For the purposes of discussion, I move House Bill 2555 be passed favorably.
Is there a second? Seconded by Proctor. And for discussion. Any discussion? If not, you wish to close or comment?
I didn't make a motion, so I can't close.
Representative Neighbor, you have some comment. Go ahead.
Well, we had some email correspondence. I think it was Mr. Barker that crafted the correspondence. He gave some indication that the chair might be offering an amendment. Are we going to see that? Because with or without that amendment, I can't support the bill. It was a very short one, and if it is offered, I would even offer, if it's been drafted, I would even be willing to offer it, but without that amendment, I can't support the present bill.
I am not aware of any amendment that I presume that I might give, but I'm open to an amendment or a suggestion of amendment to this, to HB 2555. Representative Neighbor.
Thank you, Mr. Chairman. I would move an amendment to extend that 4 calendar year to 7 calendar years. And the rationale behind that is having discussion with Secretary of State's office to make sure that people have had time and it's not rushed off. I've had a lot of people that say, don't cut me off. And they're not good voters. Basically, they're not good voters. But many of them may have been out of town for some reasons, for emergencies, were inconsistent, and they would like that opportunity. I have no problem with blending or taking those off after a period of time. I just think 7 might be more reasonable, and the general public would be more accepting of that than just the 4 years.
Representative Neighbor, if you would like to make that amendment, would you withdraw your?
I will be glad to.
And the second? The second was? She can do it to withdraw. Sure. Okay, very good. To amend your motion. Okay. To change to 7 years from 4 years.
Yes, correct.
All right. Thank you. Thank you, ma'am. Is there any other comment? Yes.
Well, first, Mr. Chair, did somebody second her amendment? I didn't hear.
Oh, for the 7 years. Is there a second?
Second.
Seconded by Representative Miller. And is there a comment? Representative Proctor.
Thank you, Mr. Chair. So I just want to make clear to the entire committee that this is already a 7 to 8 year process to remove somebody from the rolls under this bill. Because what this bill says is that if somebody is engaged in no voting activity at all, or election-related activity at all, not just voting, but even requesting a ballot or doing another registration card with a new address, anything at all that a voter does resets the clock. So you have to wait 4 years with them having absolutely no communication with the election office or any of these election-related activities. And then it starts another clock where you got to wait 3 to 4 years for 2 federal election cycles to pass. So if we were to approve this amendment, it would be 10 to 11 years to remove a voter from the voter rolls for inactivity. And that is, in my opinion, excessive, Mr. Chair.
Any other comments on the amendment? Yes, Representative Dodson.
Yeah, I have basically the same feeling. Particularly in areas where we have high turnover. You know, if you're out west, you may not have an issue at all because people tend to stay in the farm and so on. But around where I am, and I'm sure where the representative is from, the turnover is very high. And you might be going out and find 3 people registered at the same address. The only controversy, I think, that we had during the presentation of this at the beginning was when we sent the notice out, or the request, whether or not it had to come back. I'm still not clear on that part. But I think we settled out on saying it did not have to come back. The issue there being the present occupant could simply put it in the trash.
Yes, Representative Proctor.
Thank you, Mr. Chair. Thank you for the question. Several people did misspeak during the hearing. It does not have to, that card does not have to be returned undeliverable. It just has to, it either is returned undeliverable or never comes back at all. But then at any time after that notice, confirmation notice is sent out, if that voter engages in any voting activity, election-related activity at all, as I laid out, then it restarts the clock at 5-6 years ago.
Which really is a positive thing, because we know that they're there.
Right.
And that's the main thing, is that we know they're there and they intend to be a voter at some time, or they want to be recognized as such.
Absolutely.
Okay. Representative Meyer.
Thank you. I just want to clarify. So, because that was a very confusing back and forth there. So are we saying, and maybe this is a good question for you, that it has to come back undeliverable, or it can just not come back at all, and then it starts that clock?
Yeah, if it doesn't come back at all, or if it comes back undeliverable, either of those things would start the 3 to 4 year second clock, to where if no election activity occurred, the voter could be removed from the rolls.
So the voter would not even need to respond to the notice? So I'm just trying to, in my mind, the way I'm picturing it is someone gets sent this notice in the mail, they ignore it, they throw it in the trash, maybe they don't live there, nothing happens to it. And so the Secretary of State's office doesn't have any record of them receiving it because it hasn't been returned undeliverable. They also don't have any record of them not receiving it. So then no matter which direction that goes, it still starts that clock ticking.
Yes, but I will take issue with one thing you said. If the voter didn't get the notice because they didn't live at that address, that's why the notice was sent, was to confirm that they still live at that address. And so unless they've moved next door in the same precinct, they shouldn't be voting in that precinct anymore. And so that's what the point of the notice is to see if they still live at that address. And if the new tenant at that address gets that notice and throws it away, then that notice did what it was supposed to do, which is confirm that that person no longer lives at that address.
I do understand what you're saying, but I don't know if you recall what I had brought up as a point that evening as well, where the example that I gave is that I have clients in my practice who use our address specifically as a mailing address, and the Secretary of State's office, I think Mr. Barker maybe confirmed that because you can have a separate mailing address from your voting residential address, that they would be mailing that out to the mailing address instead. So if, for instance, that piece of mail was to be sent to me at my office, or I'm no longer there, so they maybe wouldn't even think to retrieve it on behalf of the client, then it would just start the clock ticking at no fault of, the voter. So that's kind of where I'm getting wrapped up in this, and I can't really support either of the amendments at this point. I know that we had, Representative Miller was speaking of one, I think we had tried to put a fix in, but it doesn't sound like that one came through. So I'm just trying to get clarification on this because I'm very concerned about this specific point.
Respond.
Yes, thank you, ma'am. And yes, Representative Proctor, then we'll move on to the next.
Thank you, Mr. Chair. I do take your concerns to heart. What I would point out is that the U.S. Supreme Court in 2018, as I testified, the U.S. Supreme Court in 2018 heard a similar law from Ohio that was even less cautious, to use the term that you gave me, Mr. Chair, was even less cautious, that only waited 2 years of no activity before it sent the notice, was found constitutional and not an unreasonable burden on voters. Thank you, Mr. Chair.
Okay. Next, Representative Howell.
I think you already answered the question, but just to restate, thank you, Chair. So the only way to restart the clock would be by completing the application that the election office sends out.
That is not correct. Let me give you the list of things. Any of these things that a voter, if they didn't return the confirmation notice, any of these things would reset the clock as well. If the voter voted, if he went to the wrong polling place and tried to vote at another polling place, if he requested or submitted an advance ballot, if he signed a petition, like somebody comes by with a ballot petition, hey, I want to be on the ballot, and they sign it, that is election-related activity. Or if he responds to any mail from an election official. So if they send another confirmation notice, or if they send, a request of any kind, any of those activities would reset the clock. And it's not on my paper here, but also if they were to fill out a registration form changing their party, fill out a registration form changing their address, that would also reset the clock. All the way back, not just to the confirmation notice, but all the way back to those 7 years. Thank you, Mr. Chair.
Representative Neighbor.
Thank you, Mr. Chairman. I guess I have one concern with the way that public mail is going right now. I know of people that have gotten Christmas cards a year late, or bills 4 months after they were due, or they just didn't get them, lost in the mail. And I'm not blaming the mail department, but it happens, and it's going to happen around. So that was just one example of that, and that's why I brought that up and brought this up for discussion. So thank you.
Thank you, ma'am. And Representative Osmond.
Thank you, Mr. Chairman. So I don't know how many people this bill, as it either stands or is amended, would affect. I suppose if we were to ask legislative research, they could come up with an answer on that. We probably should have, and we could figure out exactly how many people. But in my mind, it's one of two scenarios. It's either a large number or it's a small number. And if it's a small number that this would affect, that this would clean up, my question would be, why are we going through the process of bothering to clean up such a small number? And if it's a large number, then we're looking at a large number of people that we're potentially disenfranchising. And why are we doing that? So in either scenario, what is the point?
Okay, right now we have Representative Miller would like to be recognized. I recognize you, sir.
I recognize you as well. I wasn't bothered by this bill the other day until I was properly corrected on my misunderstanding of how this mail is being sent. And I don't understand why, if we're trying to clean it up for those people that have moved, we're not sending it do not forward. Because that would be the most effective way of recognizing those people who have moved and who do not remain currently properly registered. But having learned that you can send these out to people who are still living there, and then that does end up resulting in the removal of their name, then I have a problem with that. I thought we were going to, I thought there was going to be an effort today to establish that when your name got improperly removed, that is, you were still there and legally entitled to vote, that would be a reason to count your provisional, that you'd be allowed to cast a provisional ballot, and if your residence had not changed, you could cast a ballot that would then be counted. Since that's not prepared, and I don't like doing sloppy work, I'm not going to try to throw a conceptual motion out there. But I will, if this bill comes out, I will vote against the bill in its current state, and if it comes out of committee, I'll prepare a floor amendment for that fix. And I think that fix is important to the people we're talking about, and it would also, in my mind, make the bill palatable, and I'd be able to support it. So I'm going to support the motion that's being made at the moment. And again, I intend to vote no anyway.
All right. And Representative Proctor, thank you.
Thank you, Mr. Chair. Just to respond to the representative from Topeka. I believe that the confirmation notice does say do not forward. Is that the big yellow card that they send out says do not forward? If that's not the case, I apologize, but I'm almost certain that that's the case. The second thing is, if you show up at a polling place, and you have been removed from the voter rolls, you get a provisional ballot. And if you can demonstrate that you were wrongly removed from the voting rolls, at the canvas, you can have your vote counted. And so that mechanism is already in statute. Thank you, Mr. Chair.
Representative Miller.
Well, actually, I have a vivid memory when people correctly correct me. And it was Mr. Pifo. I was the one sitting here saying this mail gets forwarded. He had the yellow card, and he showed it to me where it is not sent do not forward. And so again, I remember that correction. Secondly, all that you just said is exactly what I would offer in an amendment, because right now, no, once you're removed, you can't cure it on Election Day. I wish you could. I wish we had Election Day registration, but we don't. But this amendment would fit exactly the description you just gave of when a ballot could be counted when you were mistakenly removed. And like I said, I will, if this reaches the floor, I'll get an amendment crafted that is correct and explicit and makes that clear, and would hope that you would support it. Thank you.
So I apologize if I am incorrect about the confirmation notice, but I do want to make clear what I said is not that you could cure the problem at the election day at the polling place. What I said is you would be given a provisional ballot, and you could cure at the canvas if you could demonstrate that you were wrongly removed from the rolls. I just agreed with you about that. So thank you.
All right. Representative Neighbor. You can make it as easy as you like. You're the one that's making the motion.
Oh, my God. Anyway, I'll do that. I'll withdraw my conceptual extension amendment and take it back to passing out HB 2555, favorable for passage. Thank you.
And we still have a motion and a second, is that correct? Okay. Original motion and the original second is good. So all in favor of passing this out as 2555, say aye.
Aye.
All opposed? And abstain. There's one opposition. House Bill 2576, 2577, and 2579 all come from the Ethics Department. Yes, sir. Oh, vote recorded, so all the proponent, or all the ayes were, raise your right hand. One, two, three, four, 5, 6, 7, 8, 9. I believe it's 9, is that correct? And all opposed? 1, 2, 3, correct? Okay, 9, 2, 3. Very good. All right. All right. Thank you. All right. These might move faster, folks. 2576, 2577, and 2579 are all cleanup bills from the Ethics Department. And I will entertain a motion on HB 2576 as to disposition of this bill.
Mr. Chair,
Say.
I move 2576 favorably for passage.
All right. Is there a second? Seconded by Representative Miller. Okay, for discussion? Okay, if no discussion, all in favor say aye. Oh, excuse me, pardon me. Procedurally.
Close on my motion.
Did you move your motion? Thank you. And all in favor say aye. All opposed? One opposition. Okay. And so, and abstain, and the motion passes with one opposition. HB 2577, do I have a motion? For discussion. Representative Miller.
I move that House Bill 2577 be recommended favorably for passage.
Okay. Representative Dodson gives a second for discussion. Is there discussion? And for the audience's edification, making technical amendments to the Campaign Finance Act, extending the time frame for investigative hearings before the Governmental Ethics Commission, and opening commission investigation to federal officials. All right. If there's no further discussion, would you like to move your motion?
I move my motion.
Okay. All in favor? Say aye. All opposed? Abstain? And the motion passes unanimous. HB 2579, requiring electronic filing of campaign reports by candidates for state office unless an exemption is granted per cause. Is there a motion? Representative Neighbor.
Mr. Chairman, I move that we pass out HB 2579 favorable for passage.
Okay. Representative Dodson, second. And for discussion? Anyone discussion before votes taken? Okay. Representative Neighbor, would you like to move your motion? There is a discussion. I didn't know what that guy was doing there. He's waving his hand.
Thank you, Mr. Chairman. As you may recall, when Mr. Skoglund was here, he had requested an amendment to the bill to tweak the language on how the filing was defined, and I believe Revisor Heim has that language to distribute to the committee today. I know it was distributed.
At the committee's discretion, if it's simple language, we can move the motion. And it just came in.
Language actually was adopted on the identical Senate bill. I can read it On line 12 there, after Secretary of State, it says reports filed by the treasurer for candidates for state office shall be filed electronically with the Secretary of State in a form prescribed by the Secretary of State. So the addition would be in a form prescribed by the Secretary of State. That's the amendment.
And the reasoning behind that was simply to keep it from coming as a fax that would have to still be completely transcribed into the record as much as any other. So, is that correct?
That is correct.
And is that your motion? Is that your amendment?
I would move my amendment.
Second.
Okay. And motion's been made by Representative Bourgeon and seconded by Representative Miller for discussion. Is it clear? This is just for the amendment. Okay. If no further discussion,
I'll close on my amendment. Thank you, Mr. Chairman.
okay. And then all in favor of the amendment to 2579, say aye. Aye. All opposed? Abstain? And back on the main bill, Representative Neighbor, excuse me.
Mr. Chairman, I would move that we pass out HB 2579 as amended.
All right. Is there a second? Representative Collins. All right. Yes, Representative Proctor, for comment.
Yeah, thank you, Mr. Chair. I'm going to oppose this bill in the committee. I'm going to oppose it on the floor because I feel like, you know, we talk so much about how we're creating additional hurdles for people to participate in the governmental process. And I know that there is a clause for the ethics department to grant waivers to this, but I feel like there's going to be a huge disincentive for them to grant waivers because it creates more work for them. And I'm afraid that some future office will be reluctant to grant waivers just on the grounds that it makes their life harder. Meanwhile, we may be barring some folks from running or participating in the process because they just don't have the technical capability for one reason or another. So I'll oppose this bill for that reason. Thank you, Mr. Chair.
Thank you, Mr. Chair.
Representative Lee, I just used my microphone. It's kind
No,
of
you're just fine.
technical.
I'm also opposing this bill. I don't like this bill. You know, if we would be requiring, if we would be requiring folks to register to vote electronically instead of giving them the paper option, people would be up in arms because we were creating another obstacle and we need to make this process as streamlined as possible. And I don't like that we are not giving, that we are requiring people to have to use technology if they're not comfortable with it. I'm also opposing this bill. I don't like it.
Any other comments before we vote on this amendment? Representative Smith.
I think it's a good bill. If it saves the ethics 3 months of work, I think people can find somebody that can help them do the electronics. So I think it's a good bill. Thank you.
And I'll just say that one of the reasons I think it's important is because we want clarity in elections. We want to know that people are providing ethical activity in elections. And if you have to wait for 2 or 3 months to find out what your opponent did, it's long past the election, and they may have not done everything according to the law, and when their report's finally filed. So I'm in favor of quick response, even knowing that with a request for an exemption, that they can get it. And the ethics department has made it very clear that they're not going to probably turn anybody down, but they'd like to have as many as they can submitted promptly so that good, clean, quick, accurate information can happen. That's why I'll support the bill. Anyone else? All right, and so on the amendment, can I, is there?
I think we're back on the bill.
We're back on the bill, just straight up. Okay. And Representative Neighbor moves for motion, and all in favor, please say aye.
Aye.
All opposed? No. And abstain? We have two noes, and the rest, I believe, ayes. So the bill passes to be considered on the House floor, to be moved to the House. HB 2585, requiring all advance voting ballots to be returned by 7 p.m. on Election Day. Is there a motion?
Mr. Chair.
Yes, by Representative Lee.
Mr. Chair, I move HB 2585 favorably for passage.
Representative Proctor, second. For discussion, Representative Miller. And Bourgeon.
I make a substitute motion, Mr. Chairman, that we report the bill adversely.
Can you explain that?
Sure. That means that I'll explain it if I get a second. I don't think we want to waste time if it doesn't have a second.
And the motion been made and seconded to report the bill adversely.
And what that would do is it would save us voting on the main motion and debating it, and we could just kill it with a yes vote on my motion.
A yes vote on your motion would simply kill the bill.
Yes, sir.
Okay. All right. It's been moved and seconded by Representative Miller and Representative, I'm running out of gas, Osman. Thank you. And for discussion on that motion, is that a substitute motion? That's a substitute motion, non-debatable. So it is debatable for the motion itself. And yes, ma'am.
No, the substitute's debatable.
Yes. Representative Lee.
Thank you, Mr. Chair. I oppose the substitute motion on the grounds that I have got no less than, 20, 30 emails probably this afternoon from folks all over the state that are not only asking, but are demanding that our elections are fair and that they have integrity in them, and that the election day is that. It is election day. It's interesting to me that these folks that are emailing me, I'm assuming that probably others on the committee have been receiving these emails as well, that Vic Miller's shaking his head. Maybe they knew better. I don't know. But that it's just interesting that it is not just my district, but it is certainly we the people, and we are a government by the people. And so I would just ask that we pass this bill out of committee and we let all of our colleagues decide for their districts what their constituents would like. And I offer that testimony or those comments rather, just based on the fact that I have gotten so many of these emails from, like I say, all across the state. So I think it's just fair to the people that we allow our colleagues to decide. So I oppose Representative Miller's supplemental motion.
Representative Bourgeon.
Just a point of clarification. Are we just debating the motion, or can I argue points of the bill? Yeah, okay.
You can argue
Thank you. All right. Well, I wanted to call to the attention, I'm going to circulate a letter here. I hope I have enough copies. This is a letter that was, as I was thinking about this, I wanted to find some additional information of why this was brought forth. And you'll see that this letter is on letterhead from former Secretary of State Chris Kobach, and it was submitted by Brian Caskey, who was his election director at the time. I draw your attention to the second paragraph, which really succinctly tells us why. The United States Postal Service has decreased the number of locations that process mail in the state of Kansas. As a result, an increase in the amount of time needed to transmit mail has occurred in the last few years in Kansas, and across the country. I would suggest to you that that has not changed, and it's probably only gotten worse. And so I think this underlying bill sends the wrong message, and I will be voting yes on the motion that's before us. Thank you, Mr. Chairman.
All right. Who's next? Representative Collins.
Thank you, Mr. Chair. I also will be voting yes on Representative Miller's motion because, for the most part, I don't like the idea of mail-in ballots. I encourage everyone I can, if they're going to vote, do it in person or use a drop box or whatever. But I understand that some people do prefer to mail their ballots, and some people, that's the best option for them. So, like this letter from the former Secretary of State says, the mail processing has gotten really slow down in my area. Used to, you'd mail something, it would be processed in Fort Scott, like 20 miles away. So it'd probably be there the next day or maybe the day after at the most. But now sometimes I have mail that takes a week or two for me to get. And like I said, I don't really like the idea of mail-in ballots, but I think a 3-day, I guess you'd call it a grace period, as it stands now, is the reasonable option. And, you know, the day of 7 p.m., that would be losing way too many people who are making an honest effort to vote and to get it in on time. And so, like I said, I oppose the original bill, and I support the motion to pass it. Well, whatever the terminology is. Thank you.
Representative Dodson.
I support the substitute motion as well. This does not affect any of you. Just let me express how I think the world works. People who want to advance a bill send out a notice, and it encourages everyone in the free world to send in an email to all of the people who represent them. So we've got to be very careful. I mean, I must have 100 emails in that folder titled "This Bill." Everything from "you must," "I demand you do it." So, I mean, you have to know your constituents. If this is truly a demand, then you've got to support your constituents. That's why we're here. But these kinds of things crop up all the time. I got 250, maybe 252, I lost count, when we did the hunting bill last year. So, I mean, you just got to kind of put all this stuff in your thinking cap and then remember what your constituents actually want. And again, I'm not trying to influence how anybody thinks about their own constituents. That's just my take on it. Thanks.
Representative Proctor. Thank you, sir.
Thank you, Mr. Chair. I'm going to oppose this substitute motion, though I'm interested to find that my colleagues on the other side of the aisle are agreeing with a letter from Chris Kobach's office. And I'll tell you why I'm supporting this, or I'm opposing this motion, and I'm supporting this bill. There is a great deal of consternation about, and we heard it all through the testimony, these 32 or 23,000, I've forgotten the number, of folks who would be disenfranchised if we were to change the date. And we even had somebody come in, I think, and testify that it disproportionately disenfranchises, I think is the word they used, people of color. I think that is frankly selling our constituents and selling Kansas voters short. I think that we have plenty of evidence from the Secretary of State's office that before this was a law, almost the exact same number of people missed the deadline when it was only when you had to have your ballot in by Election Day. That this almost the exact same number of people didn't get their ballot in on time, which says to me that Kansas voters are smart enough to figure out what the rules are and to follow the rules. Another the other thing that I would ask you to consider as you consider this motion, this letter comes from the time when they were considering this, and they didn't know things then that they do know now. And the chair, the former chair of the committee, who I believe sat as the chair of the committee when they approved this bill and sent it out to the House and it became a law, regrets it because he saw how it worked when when the volume of mail-in ballots increased. He regrets that he voted this out of the committee, the 3-day extension. He regrets that the bill passed on the floor of the House. And his spouse, the Representative Esau, she brought this bill to correct that error that the House made in 2017 and that the state of Kansas made in 2017. So while I agree that at the time everybody acted in good faith and thought it was a good idea, now we have a demonstration of how it all falls apart when you have massive mail-in ballot voter turnout in an election. It breaks it. It breaks it, and so this will fix that problem. Thank you, Mr. Chair.
Thank you, sir. And Representative Lee.
Thank you, Mr. Chair. A couple of comments. We have dates, important dates that people have to adhere to all the time. Everything from doctor's appointments to April 15th. And people are mindful of those dates. And so I guess I would say that, you know, in being in this committee, one of the things that I've come to really appreciate is the currency of our ballots. I would call it that because that's how important and how precious our ballots are. And if people are so mindful of the power of their ballot, they're going to be mindful of the date in which it's due. And so I guess that's, you know, as I sat through that hearing, that's just what I kept thinking is just the power and how sacred our ballots are. And if people are really that concerned and understand the weightiness of that, they're going to make sure they get those ballots in time and be mindful of those dates, just like they are, you know, of other important dates in their life. The other thing, the other comment that I want to make is to my colleague to my right. He said something about getting these emails and, you know, and knowing our districts and I had spoken, had the honor of speaking at an event actually in Wichita a few months ago called The Reckoning, and it was an election integrity event. And I met many of those folks that actually are, not all of them, certainly, I don't recognize all their names, but a lot of them from across the state. And so I guess it's very personal for me in knowing a lot of those folks that did send those emails in, that we the people that are directing us to make laws to protect them have genuine concerns and are not just, you know, I know we get a lot of those form emails and you just think, do they even really, is that just a couple of clicks of a button? But I didn't receive any form letters. Actually, all those emails that I got today were actually a little bit different. And so I guess that's my response, is that I have talked to a lot of those folks. I know they're not form letters, and I know that there's genuine concern about the elections and the irregularities that we've seen. And I think that people just want the opportunity to correct that. Thank you, Mr. Chair.
All right. Any other comments before Representative Osman?
Thank you, Mr. Chair. I believe that we have, I support free and fair elections in Kansas. And I think that I don't go out on a limb to say that everyone in this room supports free and fair elections in Kansas. Personally, I believe that we have free and fair elections in Kansas. And we've had testimony, not on this particular bill, but from the Secretary of State that says that the elections were secure. They are secure. They will continue to be secure. Now, I understand that certain people feel that certain people within the general population feel that there weren't fair elections. And you can feel however you wish to, but they provide no evidence to support the question of that there was any problem with it. And this bill is trying to solve an issue that there's no evidence that there's an issue to solve, that there's no problem to be had to solve. And so I don't see a need for a bill that tries to rectify a problem that does not exist. So I would stand in support of the motion by Representative Miller.
If there's no another comment, Representative Miller, do you want to move your motion?
We will close in this way, Mr. Chairman. I probably have a hard time concealing my glee when one of my few pleasures left in life is to pick apart the reasoning and logic offered by my friend from Leavenworth. But in the interest of time, I will spare the committee my eloquence and simply move my motion.
All right, Representative has moved his motion to kill the bill. Report adversely. All right. All in favor of that motion, please say aye.
Aye.
All opposed?
No.
Okay. The ayes have seem to have it, and I believe the ayes have it. And if there's no request for division or recorded, okay. Okay, a recorded vote. So all who want to have their vote recorded, please raise your hand. And that's is that 3 in the negative? 3 no. Okay, 1 yay. Okay. Representative Proctor is a no. Representative Lee is a no. Representative Collins is an aye. Aye. And Representative Osman, aye. Is there any others? Representative Tao, aye. Howell is a no. Okay. All right. Say again. Did I miss anybody? Okay. All right. And now for the body, the last bill we have before us is the very bill that we worked at the first of our consideration. Representative Topiker.
Mr. Chairman, in listening to the committee, ask questions and try to get answers from the Secretary of State to others that appeared on WebEx, it seems to me that my summary of all those comments is that the supporters of the bill like it, but have all of these questions. Even the opponents liked some parts of it, but still had all these questions. And to me, Mr. Chairman, I think that this committee doesn't understand and maybe will never understand how election machinery works. And if they do understand it in one county, it'll be different in another county. So, Mr. Chairman, I would ask you not to take action on this bill, and for somehow we get a committee to tour maybe one election office, maybe several different types of election offices, county clerk's offices, and at least try to get an understanding of how the equipment works. Because I believe the Secretary of State's office couldn't really answer how, some of the questions that were asked and how those are carried out and implemented in the office, the precincts themselves. So I would ask that the committee just leave this lay on the table at this point in time, Mr. Chairman.
And not tabling it, but lay it on the table. And also, I would just respond and see if this sounds amenable to you, and that is that in April, the month of April, we may have time that the committee could actually do a tour or two or a visit or two to election officials, and when we're in the in between then and the veto session. You want to?
Mr. Chairman,
Without Representative Miller. Yes, sir.
I agree to that, and there were so many good comments made to this one-page bill that I just think that this has some future chances of passing, and I think that we could be progressive and move down this road of looking at the ballots or at an early point in time. But since there seems to be so many questions, maybe we could take it up later, and maybe that would give me a chance to draft some more amendments and more clarification.
We thank you, Representative Topiker, and I thank you all committee. I've chaired a few meetings in my life, but this has been one of the most, over the last couple of years, this has been one of the most rewarding, because most of the comments that are made are done with respect to the same goal. You may think, well, one party is going from one angle and one party is going from the other. But when we have a full discussion, we end up talking pretty much from the same angle, and that is towards fair elections, towards integrity, towards a clean election. We want a clean election, and so we end up looking at it amazingly sometimes in similar ways by the time we get done discussing. You guys have been very respectful in our considerations of our House considerations, and when we come back around after turnaround, we will probably be considering some bills coming from the Senate. And in the meantime, you have moved some bills out to the House for possible consideration, and I'll be looking for anyone who would like to be a carrier of a bill. If you let me know that you would be interested in being a carrier and which one you'd like to carry and present on the House floor if it does get considered. So please contact me if you have for that.
I'd like to carry that one I voted against.
Yeah, that's been duly carried right to the can. All right. All right. Anything else for the good of the committee? It's almost 6 o'clock. Is there anything else we could talk about? No. Maybe being gone. All right. We are adjourned. Thank you so.